students. Hope you all are stay safe and healthy. Today we are going to discuss Indian Easement Act. This is a very important and this is very common right, which is very common in the rural areas as well as in the urban areas. This is a beneficial enjoyment of the dominant tenement. This easement right is not the natural rights. These rights are provided, these rights are acquired by one person to another person. So, let's see what is in easement. Easement under Indian Easement Act 1882. According to section 4, an easement is a right which the owner or occupier of certain land possesses. As such, for beneficial enjoyment of that land to do and continue to do something, or to prevent and continue to prevent something being done in or upon or in respect of certain other land not his own. Suppose A, the owner of a certain house, has a right of way over his neighbor B's land for purpose connected with the beneficial enjoyment of the house. This is an easement. Now, what is the dominant heritage and what is the servient heritage, and who are the dominant owners and who are the servient owners? The land for the beneficial enjoyment of which the right exists is called the dominant heritage, and the owner or occupier of that land is called the dominant owner. And the land on which the liability is imposed is called the servient heritage, and the owner or occupier thereof is called the servient owner. Suppose A, as the owner of a certain land, has a right to go on his neighbor B's land and to take water for the purpose of his household out of a spring therein. Here A is the dominant owner and B is the servient owner. So, what are the essentials of easement? From the definition we can get the points of the essentials of easement. First one is there must be two tenements. These tenements must be distinct from each other. The servient tenement and the servient owner and the dominant owner. They are the distinct from each other. Third essential, it exists for the beneficial enjoyment. This is very important. Beneficial enjoyment of the dominant tenement only. It is not a personal right. The easement right is not personal. It is not a right in gross. It is not for the beneficial enjoyment of the servient owner. This is the beneficial enjoyment of the dominant tenement, but this is not the beneficial enjoyment of the servient owner. It is incorporeal right in rem. Now, what are the difference between the natural rights and the easement? In natural rights, the incidents and advantages provided by nature for the use and enjoyment of one's property like light, air, etc. are known as natural rights, which are recognized in the eye of law as the rights annexed to a particular land. An easement is a right which the owner or occupier of certain land possesses to do and continue to do something in respect of certain land not of his own. The second difference of natural rights and easement is in the natural rights are not created by the prescription or grant. The natural rights are not created by the prescription or grant. No one can grant, no one can prescribe such items, such natural rights. Easement is created by prescription or grant. There is a natural enjoyment. In the case of natural rights, there is a natural enjoyment. But in the case of easement, there is beneficial enjoyment of dominant tenement. In natural rights, these rights are provided by nature, but in easement, these rights are provided by a person. In natural rights, require no express or implied consent of any person because these are provided by nature. So there is no requirement of implied and express consent of any person. In easement requires express or implied consent of servient owner. What are the kinds of easement? There are various kinds of easement. Continuous easement, discontinuous easement, apparent easement, non-apparent easement, etc. What is continuous easement? A continuous easement is one whose enjoyment is or may be continual without the act of man. Suppose a right annexed to B's house to receive light by A window without obstruction by his neighbor A. This is a continuous easement. A discontinuous easement is one that needs the act of man for its enjoyment. Suppose a right of way annexed to A's house over B's land. This is a discontinuous easement because it can be obstructed by his neighbor. What is apparent easement? An apparent easement is one the existence of which is shown by some permanent sign which, upon careful inspection by a competent person, would be visible to him. Suppose rights annexed to A's land to lead water thither across B's land and to draw water thence by a drain. The drain would be discovered upon careful inspection by a person conversant with such matters. What is non-apparent easement? Non-apparent easements have no permanent sign on the SERVIENT heritage, which may be visible to an observer. A right annexed to his house to prevent B from building on his own land. This is an example of non-apparent easement. Section 8 says who may impose easement. An easement may be imposed by any one of the circumstances. Under a lease for 20 years, the lessee may impose an easement on the land to continue during the time that the lease exists or for a shorter period. During this period of 20 years or less than 20 years, the lessee can impose easement. Again, A, B and C are the co-owners of certain land. A cannot, without the consent of B and C, impose an easement on the land or any part thereof because they are the co-owners. Without the consent, the other party cannot impose the easement. Again, A and B are the lessees or same lessor. The lessor is the same and lessees are different. A and B, they are the lessees. Here, in the case of lessee, what the lessor is the same person, A for 5 years of the field X. The lease period of A is 5 years for the field of X. And B is the lessee of field B and his lease period is 10 years. A's interest under his lease is transferable, but B's interest under his lease is not transferable. Here A may impose on X in favor of B a right of way terminable with A's lease. What are the difference between imposition and transfer of easement? The imposition of easement means the creation of an easement by the owner or occupier of the land on which it is to be exercised. It is the voluntary creation of a right which did not exist before. Again, transfer of an easement means the transfer of an existing right by the dominant owner. It is a voluntary conveyance of an existing right. Who may acquire easement? Section 12 says acquired by the owner of the immobile property for the beneficial enjoyment of which the right is created or on his behalf by any person in possession of the same. Easement may be acquired one or two or more co-owners of immobile property may as such, with or without the consent of the owners, acquire an easement for the beneficial enjoyment of such property. No lessee of immobile property can acquire for the beneficial enjoyment of other immobile property of his own an easement in or over the property comprised in his lease. No more today. Next day we will discuss with another topic of Easement Act. Thank you.